I'm Lane Strother. I'm an attorney here in Mountain Home. I practice law with my wife Judy. We've been in the Strother firm for almost 30 years. We have practicing it with us Bill Anderson, who is also a lawyer. What I'd like to talk to you about today are powers of attorney and advanced directives. And basically a power of attorney, when I first got out of law school, I had somebody ask me, what's the difference between a lawyer and an attorney? And to be honest with you, I could not tell them. So I went to Black's Law Dictionary and looked it up, and a lawyer is somebody who is versed in the law. An attorney is somebody that you have that represents you. So when you give somebody your power of attorney, you're asking them to represent you, whether that's in a purchasing property, signing checks at the bank. You have various types of powers of attorneys. You have a limited power of attorney, and this is where you give somebody the power to represent you in a limited area. For instance, people would come down and they want to buy a home here. They have the limited power to sign checks to buy the home, to sign the documents at closing. That's a limited power of attorney. And then you have a general power of attorney, and that pretty well allows that person to do anything that you can do. And they can do that while you're alive and while you're competent. And that's another thing that's important, because that brings up another sub-area of powers of attorney, and that's the area called a durable power of attorney. And what the durable means is it's good even after you become incompetent. So generally what people are going to want is a durable power of attorney, durable general power of attorney that would give them the power to do anything and everything that needs to be done to take care of whatever problem might come up. Now, I think that I talked about the powers of the attorney. The advantage of having it is it allows somebody else to do this if you're not available, not able, or don't want to. The difficulty with it is that it cuts with a two-edged sword. So if that person chooses to sell something of yours and you've given them your durable power of attorney, then they have that right. They can sell your home, they can sell your cars, they can sell, with a durable power of attorney, general power of attorney, they can do whatever they choose. They can take your money out of your bank and do with it whatever they choose to do with it. The other difficulty with a power of attorney is that it ceases when you die. So a lot of times people will give somebody their power of attorney to take care of their bills during the last days of their life, and then they die and they still have bills to be paid, but that power of attorney ceased when they died. So again, I go back to encouraging people to consider a living trust, which is to me a much better instrument than just a power of attorney. And I do talk about springing powers of attorney, and again, that's a term that's used and it has a specific meaning in that at a time in the future it will spring into existence. So a lot of times people will say, if I become incompetent in the future, then my power of attorney will go into existence, and the person can act for me. The only problem with a springing power of attorney is you have to have that event to occur, and then you have to have some proof that that event occurred, and normally that's my incompetency. And so who's going to determine my incompetency? Will it be a doctor? Will it be my lawyer? Will it be a combination? Will it be a judge? What requirements need to be met to have a springing power of attorney? Often people come in and they realize that they have given somebody their power of attorney, and that person is taking advantage of it. And so then at that point they want to revoke that power of attorney, and they can do that at any time. They have to sign the revocation of the power of attorney, and then they need to notify the person that had their power of attorney that their power of attorney has been revoked. Let me talk to you a little bit about advance directives, and they kind of fall into the power of attorney because the first type in an advance directive is called a healthcare proxy. And this is a healthcare power of attorney where you're giving somebody the power to make healthcare decisions for you if you can't make them yourself. Oftentimes people have a stroke, something like that. They go to the hospital. The doctors need to know, what do we do with the doctor? Let me back up. The doctors know what to do, but let's say they get you past the point where they need to discharge you. The person with your power of attorney will be able to say, let's take mom home, let's take dad to this spot or that spot, and they can do that with a healthcare power of attorney. The other type of advance directive is called a living will. I personally prefer to refer to it as a death with dignity declaration. And what that says, in essence, is that if I should have an incurable or irreversible condition with no hope of recovery and death is imminent, then I do not want to be kept alive by artificial, extraordinary life support systems. And I think that's very important for people to have in their little arsenal, because at some point we'll reach that stage. And rather than the kids having to make the decision of what do we do with mom or dad, it's so much easier for everyone to be able to say, well, this is what mom wanted or this is what dad wanted, and we'll follow their wishes rather than having to make that decision themselves. If you have any other questions, please feel free to call me. My telephone number is 870-425-3464. We have a website. It's www.strotherfirm.com. That's STROTHERFIRM.com.